Well, good morning. I'm Jagendra Rana. The topic of the day is arbitrability of insurance disputes. Arbitrability of insurance disputes. The Insurance Regulatory and Development Authority of India has removed the arbitration clause for individual policyholders of general insurance, except for commercial policies. So, according to IRDAI's October 27 circular, the decision was taken after a comprehensive study of the existing arbitration clause in general insurance for retail and commercial policies in consultation with various stakeholders. So, the study found the clause to be of limited scope, paving the way for its amendment. IRDAI noted that retail policy should be kept out of the purview of the arbitration clause, as there are other forums like the insurer's grievance system, insurance ombudsman, the consumer and civil courts to look into their complaints, and insurance related disputes. Thus, under Section 14 of the IRDA Act 1999, it exercised its powers to amend the arbitration clause. The amendment is as follows. As per the circular, no policy in the retail lines of business will have an arbitration clause from now on, except for commercial lines of business. So the clause for a commercial line of business is as follows. That is, the parties to the contracts may mutually agree and enter into separate arbitration agreement to settle all disputes concerning this policy. Arbitration shall be conducted under and in accordance with the provisions of the Arbitration and Conciliation Act 1996. So, as the circular is enforced immediately, we need to know the effect on the policies to be issued on or after the date of circular and on the existing policies. Because the arbitration clause will be deleted for all the new retail policies, the clause will apply only to the commercial policies. Though the clause is removed from the new retail policies, it will still be valid till the policy term of the existing policy unless a policyholder specifically requests the insurers to replace it with the clause. So, besides in the case of commercial policy, the arbitration clause will be considered or replaced from the date of renewal, whenever it falls on or after the date of the circular. So, from now onward, there will be no arbitration clause available in the retail general insurance policies, but only in the commercial policies. In fact, what is this arbitration clause? This is important to understand. Because arbitration is a setup for dispute settlement in the case of general insurance. And this is to settle disputes between the insurer and the policyholders. So the arbitrator examines the dispute and related facts to the grievance and decides how to resolve it. The arbitration clause is a clause in a contract that requires the parties to resolve the dispute. Following what is mentioned in the arbitration clause, it binds the parties to resolve their issues outside the courts. So the clause will differ for different contracts, so that parties should remain cautious and check that the clause covers all the issues and the claim as well as required quantum. The circular has become effective from the date of its issuance. Now, the Insurance Regulatory and Development Authority of India has settled the ambiguity surrounding arbitrarily of insurance disputes by its circular titled Amendment of Arbitration Clause in General Insurance Policy dated October 27, 2023. This issue stems from the All India Fire Tariff issued by the Tariff Advisory Committee on May 31, 2005. So the actual Section 64U of the Insurance Act 1938 provided for the constitution of the TAC, that is Tariff Advisory Committee, and doing it with the power to notify tariff the other policy terms for insurers in as much as legal effect was concerned. So such circulars by the TAC were binding on all insurers. In 2015, Section 64U of the Act was repealed and the TAC was abolished. As a bridging provision, Section 64ULA of the Act provided that the circulars issued by the TAC would continue to be binding unless specifically denotified by the IRDA in the official gazette. So accordingly, the All India Fire Tariff was issued by the Tariff Advisory Committee, which continues to be in force. And All India Fire Tariff provides a standard fire and special peril policy form under Section 2nd and an arbitration clause under paragraph 13. So this clause stipulates that the disputes relating to quantum of payment where liability has been accepted shall be referred to the decision of the sole arbitrator, independent of all other questions arising out of the dispute. But the clause further provides a clarification that no dispute shall be referred to arbitration where the insurer has disputed or not accepted liability under the policy. The clause says if any disputes or difference shall arise as to the quantum to be paid under this policy, liability being otherwise admitted, such difference shall independently of all other questions be referred to the decision of a sole arbitrator to be appointed in writing by the parties to, or if they cannot agree upon a single arbitrator within 30 days of any party invoking arbitration, the same shall be referred to a panel of 3 arbitrators comprising of 2 arbitrators, one to be appointed by each of the parties to the disputes and difference, and the 3rd arbitrator to be appointed by such 2 arbitrators, and arbitration shall be conducted under and in accordance with the provisions of the Arbitration and Conciliation Act 1996. Now it is clearly agreed and understood that no difference or dispute shall be referable to arbitration as hereinbefore provided if the company has disputed or not accepted liability under or in respect of this policy. So it is hereby expressly stipulated and declared that it shall be a condition precedent to any right of action or suit upon the policy that the award by such arbitrator or arbitrators of the amount of the loss or damage shall be first obtained. So this arbitration clause created a distinction between disputes involving unaccepted liability and those with accepted liability but quantum of payment being disputed. So the latter is arbitrable as per the arbitration clause while the former is not. So this bifurcation invariably will lead to a plethora of cases where the subject matter was in the grey area of arbitrability and non-arbitrability. For instance, for policies where the claim was accepted for one of the 2 losses, it becomes a conundrum whether this was a dispute relating to quantum of payment, since one part of the overall claim was accepted, or a dispute where liability was not accepted, since the relevant part of the claim was completely denied. So such instances initiated a pertinent query on whether the dichotomy created by the TAC was actually a false dichotomy, since in any dispute as to the denial of a claim was consequentially also a dispute as to the quantum of payment. For instance, in the case of Charanjit Lal Sodhi, Caledonian Insurance Company versus Caledonian Insurance Company Limited, the Delhi High Court harmoniously interpreted the arbitration clause and observed that the question of whether any claim exists is only an earlier step in the process of determining the quantum of payment. Therefore, an arbitrator has to be adjudicated upon both these aspects. However, in the case of Kohinoor Steel Private Limited versus Balaji Area and General Insurance Company Limited, the Calcutta High Court strictly interpreted the clause and rejected the arbitrability of the claim that was fully denied by the insurer since it was not related to the quantum of payment. So in the case of Shivalia Construction Company Private Limited versus National Insurance Company Limited, the Delhi High Court went a step ahead and put it upon the arbitrator to decide the question of arbitrability further adding to the ambiguity already in existence. So the Supreme Court had the opportunity to examine this issue in a special petition in the matter of Messrs. NIC versus MIS versus Messrs. Nippon Paper Firm Food Pack Private Limited. While an order dated January 9, 2023, the apex court observed that the extent dichotomy invariably leads to confusion, multiple litigation, piecemeal decisions, and chances of conflicting orders. So while the circular, the IRD has cleared all subsisting confusion and allayed the Supreme Court's concern about the multiplicity of litigation and chances of conflicting orders. The circular provides the following: the all policies issued under the retail lines of business shall not have any arbitration clause. This essentially removes arbitration as a form of redressal for retail policies and redirects a retail policyholder to more cost-friendly dispute resolution methods, such as insurance ombudsman and the consumer forum. So for policies issued under the economical lines of business, the circular categorically provides that insurance policies shall have a clause stipulating that the parties to the contract may mutually agree and enter into a separate arbitration agreement to settle any and all disputes in relation to the policy. Such an arbitration has to be conducted in accordance with the provisions of Arbitration and Conciliation Act 1996. In order to ensure that the transition does not retrospectively affect the policies in place, this circular ingeniously keeps the extant arbitration clause valid until a policy is renewed, but provides the policyholder with the option to have it replaced with the new arbitration clause mentioned in the point provided above. It is to be noted that the circular provides that the provisions of Arbitration and Conciliation Act 1996 are to be adhered to as the Section 7(1) of the Arbitration Act. An arbitration agreement can be entered into inter se policyholders at the stage of issuance of the policy, during the continuation of the policy, and even after a dispute for claim has arisen. So given that it is prudent for policyholders to have an arbitration clause at the time of issuance of policy, insurers may develop a standard template for an arbitration agreement which can be entered into during the policy issuance itself. It's also pertinent to note that unlike the previous regime, which specified an ad hoc arbitrator appointment method, this circular does not specify either institutional or ad hoc mode of arbitration. So instead, the parties are free to choose any method they seem fit. However, for time and cost sensitive disputes, institutional arbitration may be preferred over ad hoc arbitration by parties. Now, with regard to the retail line of business, the policyholders had a multitude of forums to approach. It has been held by the Supreme Court in MRMGF Land Limited versus Aftab Singh that the presence of a binding arbitration clause does not bar a consumer from approaching consumer fora for defect in services under the Consumer Protection Act 1986, now replaced by Consumer Protection Act 2019. So therefore, notwithstanding the arbitration clause in the policy document, the policyholders were free to approach consumer fora instead of instituting an arbitration. Moreover, there are other alternative dispute resolutions mechanisms available to the policyholders under the IRDAI Protection Policyholders Interest Regulation 2017. These mechanisms lay down the grievance resolution procedures for the insurers and provide that in case of grievance is not resolved, the insurers can ask the party to approach the insurance ombudsman. Under the Insurance Ombudsman's Rule 2017, disputes pertaining to all claims below Rs 30 lakh can be referred to the Insurance Ombudsman for resolution. The mandatory channel of arbitration, in addition to these alternate channels of redressal, caused confusion over jurisdiction as well as multiplicity of proceedings. So in some instances, the disputes have been declared by the courts as non-arbitrable at a later stage, thus causing loss of time and resources for both policyholders as well as insurers. So with the circular coming into force, the channel of arbitration for retail policyholders is closed. allowing them to approach more cost-effective channels such as consumer fora and insurance ombudsmen without any confusion. Thank you very much.